Members of the jury, welcome to this evening's Jury Duty Unmasked. Portia Chiffon, how you doing over there?
I'm holding steady.
That's what I'd like
It's
to
been a
hear.
day. How are you?
I'm doing well. The weather is starting to cool down a little bit in Louisiana and in New Orleans, and it feels good. It isn't hot and crazy and humid, and it actually starts to feel a little bit like fall. My sister and brother-in-law and nephew are in New York, and they've been sharing that it's been getting a little bit cold. So it's just that time of year.
Absolutely. It is what we in New York like to say. It is brick out here.
It's brick. Yes, indeed. I want to share something with you that happened to me today that me and my students, or if my mom were listening, she would say my students and I. It's amazing how things that you hear over and over again as a kid stay with you even into adulthood. My students and I had a real treat today. We were able to speak with a justice from South Africa, and he was a Supreme Court justice. In South Africa, they call it Constitutional Court. Here, we would call it the Supreme Court. But his name is Justice Albie Sachs, and he has a really tremendous, inspiring story. He was arrested at the age of 17. He very much became an activist against apartheid and became a lawyer and started to represent people who were protesting and who were trying to change the regime of apartheid in South Africa. He does get exiled. He has to leave the country because of everything that's happening and the dangers that are taking place in the country. Nelson Mandela is incarcerated, and Albie Sachs leaves and eventually comes back almost 20 years later. And when he comes back, unfortunately, people try to kill him. They put a bomb on his car, and the bomb goes off, and it takes away his arm as well as his vision in one eye. But this man, Justice Albie Sachs, gets appointed to the Constitutional Court by Nelson Mandela when Nelson Mandela is the president, and really creates this court and helps shepherd in what the Constitution will look like in South Africa. So he came to our class today and just really shared with us his life's work and some of the things that he had to navigate. And he talked about the very first thing that the court had to do, and the members of the court being appointed by Nelson Mandela, and everybody just loved and revered Mandela. And he talked about the first thing we had to do was rule against him. I guess Nelson Mandela had created some proclamations that weren't necessarily constitutional, and they said, "Sorry, Mr. Mandela, Parliament creates the law. You don't create the law as the president." And in true Mandela fashion, he goes on to the news and has a big press conference, and he says, members of South Africa, my lawyer said that I could do this, that this was within my rights to do. And the Constitutional Court has ruled, and we respect their decision, and we actually realize this is something that we could not do. Could you imagine that? Could you imagine a president showing so much deference to the courts and not saying, no, they got it wrong, but saying, hey, those are the lawyers, those are the justices, and they're the ones that are best positioned to interpret and apply the Constitution?
No. No.
Yeah.
I can dream. I can dream of that. But can I imagine it? No.
Yeah.
That's so dope.
It was really amazing, and we'll get it up on our Instagram. I got to present him with a Juror Project T-shirt as a thank you, and of course, I told him that you can't come to New Orleans and not get any beads, and so I gave him some beads, and he was so excited to. So yeah, it was a real treat, and I think my students really enjoyed it as well.
That is so dope, and it's interesting because what he talked about is really the crux of what we're going to be talking about tonight, right? Which is the integrity of process. And I think it's really dope too, right? Because, when we think about appointing our friends to these positions, right? And having their faces in these places, there's an assumption or even sometimes presumption that they're going to just look out for their people and not look out for the people, right? I think it's really dope what this man did, and I'm really glad that he got to live to tell about it.
Yeah. He was at Xavier today. He came to Loyola, and I'm not sure if he was attending any other universities, but at 90 years old, he is traveling the globe, sharing the story of what happened in South Africa and his involvement in it. And then the fun fact is he was one of the last people to actually have a jury trial, to conduct a jury trial as an attorney in South Africa, because they got rid of the jury trial system and now they only have judge trial. So I thought that was really special to be able to speak with one of the attorneys, one of the last few attorneys who actually had a jury trial in South Africa.
Did he have any thoughts about the difference in that experience of having jury trials, and the difference between having jury trials and having judge conducted trials?
I didn't ask him directly, but I got to give him a ride. I picked him up at Xavier and brought him over to Loyola, so we chatted a little bit. And he very much, it seemed to be supportive of this idea that, you know, judges apply the law and kind of have it very just, that's their role. And I was sharing with him, in our system, we incorporate the values of the community. And I think he thought that that was interesting, and it's very unique to the United States. But we didn't get to dive too deep into that concept. So I definitely have some follow-up to do with him.
Absolutely. That's dope. That's really dope. What a day.
Yeah, it was really exciting. Today, or this evening, we're going to talk about a few things. But the top line, as you mentioned, is integrity. And integrity as it relates to jurors who are participating in our system, but also integrity as it relates to the process with which our criminal legal system is trying to administer. Today, actually this morning, I had conversations with some folks from out of town, and there was actually a person who had served on a jury in Oregon, and they were sharing how it was a non-unanimous verdict because Oregon was the other state that had non-unanimous juries, and they had voted 10-2 to convict. And he had shared, if they knew the anti-Semitic origins of non-unanimous juries in Oregon, he would have been so much more concerned that that was the process that they were using to convict somebody. And he also led the conversation or chimed in that made me comment that, you know, the optics or the appearance of the jury has to satisfy our kind of appreciation of fairness before we even get to the integrity or the substance of the actual trial. So what I'm trying to say is, if we were to look at a Black person on trial, and it is an all-white jury, and we often use this image from Selma, Alabama in 1986, before we even get to whether or not the person may or may not have committed a crime, we take issue with the process, and that the process is not fair, and that if the juries do not reflect what our communities look like, we don't even get to the question of innocence or guilt, because we're like, hey, something's wrong with this jury. Tell me a little bit more about what you think how the optics of our juries can be a placeholder for fairness.
So it's interesting, right? And I think, you know, even just this concept of integrity of process, I think can be difficult to interrogate or unpack at this time, right? Because we see, it feels like there's no process anywhere. So how can you have integrity anywhere, right? But you know, just speaking specifically about the process of the creation of a veneer, right? And so for those of you that are online that did not see our first few lives, let me go back and break it down for you so it can forever and consistently be broke. Okay. So when we are talking about the process, initially, we're talking about the creation of the veneer. And that's the group of community members that are randomly selected to come into court for jury duty, right? And once that veneer is created and y'all actually show up for y'all summonses because y'all listen to us, right? Y'all will then be put in a group that ultimately goes into the courtroom, right? And from that group that goes into the courtroom, you are selected to then sit on a jury through the process of voir dire or jury selection, right? but just taking a step back at the creation of the veneer. I think that's what you were getting at, Will, right? And so, right, there are all kinds of people that are of different socioeconomic backgrounds, racial backgrounds, religious backgrounds, right? And for the most part, in most states, right, the jury commissioners use voting registration and DMV records in order to create this veneer, right? This randomly selected group of community members. But the sole use of DMV records and voting registration records assumes a lot. It assumes that everyone is registered to vote. It assumes that everyone has a state ID or driver's license. And it neglects a huge part of the population that also has value, right? That also has perspectives that can be fruitful in the deliberation process. There are opportunities to use public housing records, right? Public benefits records. And the Juror Project, actually, when we're doing our training, we note these other options to create a more diverse veneer. I hope y'all still with me out there.
I appreciate you naming that. And that there's an organization called the National Center for State Courts. And what they advise is that jurisdictions should be using lists that capture about 85% of the eligible juror population. Now, in New Orleans, we did kind of a rough calculation because New Orleans does use voter registration and DMV records as our source lists. What we found is that when we only use those lists, we are effectively excluding about 35% of people who otherwise would be eligible to serve on a jury, but since they're not registered to vote or they don't have an active driver's license, they're not receiving the summonses because they're not on those lists. And so you're highlighting a key issue that these lists are actually kind of lessening our ability to assemble that fair cross-section to represent the community during the trial because people's names may not necessarily be on those lists.
Absolutely. And again, right, it really does go back to the integrity of process, right? The idea that just because someone is not registered to vote, or just because for whatever their reasons are, they don't have a state ID, that they couldn't possibly or they shouldn't possibly be a part of this process is wild. I think another issue when we're thinking about the integrity of this process are individuals that have felony convictions. So many states across the country don't allow people with felony convictions to sit on juries, right? Shout out to the Jury of Our Peers Commission in New York. We are trying to change that. So I just wanted to head note that. But there are many states too that also recognize this sort of gap, right, in opportunities for diversity on juries. And there are many states that do allow people that have had felony convictions in the past. But it's just a wild concept, right? Just staying on the felony conviction piece for a minute, right? If we think about it in its most nuanced state, really, right? The bare bones perspective is you did something wrong, you got sent on punishment, right? And if we think about that even as from our childhoods, right? When you were put on punishment, after you got taken off of punishment, you got all of your rights restored. You were able to watch TV. You were able to go out with your friends. So I think it's wild that there is this perspective that just because individuals have felony convictions, they're okay to work. We expect them to be productive members of society, but we don't think that they can meaningfully participate in the process.
Yeah, I appreciate you lifting that up because too often people will say when we're talking about incarceration or our criminal legal system, people will sometimes say, do the crime, do the time. Okay, well, if that is a transaction, and if our laws are codified in a way that says if you steal something over $10,000, you can serve up to 5 years. You serve that 5 years in prison. Why are you continuing to be punished? Right? If this felony conviction is not allowing you to serve on a jury, it's not allowing you to vote, why is that okay as part of the punishment? And then even more so, there's just a lot of research that talks about efforts and tactics and policies that help reduce recidivism, meaning it helps reduce people perhaps falling back into having contact with the criminal legal system. What it says is if you can reintegrate that person back into the community and they have access to the rights that they feel part of that community, then they're going to be less likely to recidivate or to commit another crime. And so we have to be kind of critical of these policies that we have inherited in our criminal legal system and start calling them out. And even more kind of plainly, what's the justification? What's the reason for forever disenfranchising somebody because of something that they did in the past? I've had conversations with clients who said, listen, when I was 18, 19, I was a knucklehead. I was out here in these streets doing the things I wasn't supposed to do. But now as 37, 38 years old, I want to vote. I want to serve on a jury. And why should I be one of these rights be taken away from me for something that I did when I was a kid? Now, I want to say Louisiana, thankfully, does allow people with felony convictions to serve on juries now. There has to be a 5-year period that precedes your jury service where you're not under the supervision of the Department of Corrections. And then simultaneously, people with felony convictions in Louisiana can vote as well. So we're on the right side of the majority of states that do allow people with felony convictions to serve.
Well, I wanted to ask you, I feel like maybe a few months ago, you and I actually were talking about this very nuanced concept of people with people with felony convictions serving on juries. And I think we were talking about how there's a misconception that if you have a felony conviction, you're going to be, more likely to acquit someone. And I think you were telling me about some article or some research about folks who have prior felony convictions and their perspective on the criminal legal system that I think actually cuts into that assumption. Can you tell us a little bit about that?
100%. So I want to give a shout out to my colleague, Professor Jenny Banal, who works out in California. And there's a couple other studies of people that have done mock jury trials that have included people with felony convictions. And to your point, this myth is that when people with felony convictions get on a jury, they're going to automatically vote not guilty. And that's just not the case. And in fact, when I was testifying in Louisiana in support of the bill that restored jury rights to people with felony convictions, that's what some of the legislators were hitting me with. They were saying, why would we ever give a person with a felony conviction the right to serve on a jury? They're just going to get on there and they're going to say, no, not guilty, like automatically, not even take consideration the facts and evidence of the case. But what these studies that have shown, I think one is by a person named Mr. Wheelock. I know Professor Banal has done some. What it shows is that oftentimes people with felony convictions that serve on juries are often the more conservative people on the jury panel, right? And that they actually do two things. One, they bring a tremendous amount of perspective that's adding to the quality of that deliberation process. And then two, they aren't always the first ones to be convinced that they should be voting not guilty. They're actually probing and interrogating the process in a way that is maybe considered much more conviction prone than people would actually assume just because they have that history.
Absolutely. Thank you, Will. And Will, we have a question. Someone said, I totally feel you on the fact that the state ID and voter registration list excludes a significant swath of potentially eligible jurors. But it seems to me that many people who don't have the state ID and or aren't registered to vote tend to be individuals who have strong stances on the government overreach when it comes to privacy. So what are the strategies to get this segment of the people in the queue for jury duty? What are your thoughts?
It's a great question. Thank you for it. We believe that there should be additional lists that are used to summon jurors. And across the country, we've seen different examples. So most jurisdictions have those two lists as a minimum, the voter registration and DMV records. But we've also seen utility bills be used, tax assessor bills, child support payor list, child support payee list. And I get it. Sometimes people don't really want the government all up in their business. And at the same time, we have to think about what is the appropriate balance between us as citizens and the government that are providing some of our services and our involvement in our government, right? There are people who are tuning in to support the Juror Project that have a lot of criticisms of the criminal legal system. And they're like, I don't want to have anything to do with this system because it locked up my brother for 20 years for something he didn't do, or I've been harassed by the police, whatever it might be. And we acknowledge that. We completely are familiar with some of the harms that are committed by this system. And simultaneously, we want to make sure that people understand the power that they have to change this system, this power to serve on a jury, to help make sure somebody gets a fair trial, that they have a jury that is representative of their peers. So thinking about some of the strategies to get this segment of people in the queue for jury duty, think about how can we expand the lists that aren't just limited to voter registration and DMV records, but then also thinking about, is there a way in which we can update our forms of contact, right? I've had the same email address since 2003, right? Now my number hasn't changed either.
You got an Earthlink account, Will? You got Earthlink?
No, but
you like me more as an AOL kind of guy.
I did have AOL, and my AOL username was like Big Willie.
That
Big
tracks.
Willie something. I can't remember what it was, but
That
it
tracks.
definitely was like.
Oh, please start using that email. We gotta switch our business cards. Stat.
You know what also is a telltale sign is when you got a Yahoo email.
Don't do me, Will. Don't do me in front of these people. Don't do me. First of all, having a Yahoo account is a sign of loyalty. It means I don't buck, I don't bend, I don't break. Don't try. People are always getting on me about my Yahoo account. I'm loyal. They don't make them like me no more.
Just stating the facts.
Big Willie.
Okay. I got to figure out what the number was. It could have been Big Willie 414 because that's the Milwaukee area code. I'm not sure, but that's good times. But the point that I was trying to make is that maybe we could be using emails in a way that allows people to be contacted by the government that isn't intrusive. Or if you want to just have some people use their phones for text message, notifications, stuff like that. I definitely hear the point in this question that if these lists aren't being utilized in a way that's accurately capturing the community to represent the jury, then that's a problem, and we need to perhaps expand our thinking in terms of the ways in which we're accessing that community. So I appreciate that question.
And that's definitely important to know. And here's why, right? I just and I'm always going shamelessly plug, what we do at the Juror Project, right? When we go into communities and we're talking to community members, we are not coming from a vote or die approach, right? We are not trying to make you feel guilty because you don't want to participate in the criminal legal system, and to the point of this question, it is not up to the community members to bend in order to participate. It's up to the juror commissioners, the people that create these veneers, to expand the ways in which they are reaching community members. So I just wanted to head note that one piece as well.
I appreciate that. I want to switch to another topic real quick, but still in this concept of integrity. There was a case relating to what we would describe as juror misconduct, and it's Humphreys versus Emmons. And I just want to kind of give it a little background of what happened with this case, and then I want to hear your thoughts on it, Portia Chiffon. So we have a juror who essentially lied about her own experience during the jury selection process, during voir dire. And as a reminder for folks, when attorneys are asking questions of the potential jurors, the main thing that we're trying to discover is whether or not you'd be a good juror for this case. Not everybody's going to be a good juror for the case. There are some cases that aren't just a good fit for you. So for example, if my home just got burglarized last week and I get called for jury duty and it's a burglary case, I'm not going to be in the right mindset to sit in judgment for that type of a case. But I might be a good juror for a different case where it relates to the unauthorized use of a motor vehicle or something completely unrelated, right? So during voir dire, we're trying to assess from the attorney's perspective, would this juror be a good fit for the case or not? So in this Humphreys case, there is a juror who lied about her own experience and her own history of being a victim, similar to the very crime that was at the heart of the trial in this particular case. And she misrepresented her ability to be impartial. Now, you all will remember We never want jurors to lie. We don't want people to lie, right? There's this threshold of you indicating that you're willing to be fair and you're willing to be impartial and you're going to be listening to the evidence that's presented, all that stuff. In this case, it was a capital case, meaning that it was a case where the death penalty could be assigned. The jury originally voted for a life sentence, but there was one juror who protested, and she essentially held the rest of the jurors hostage because she wanted the death penalty for this guy. And it got really hot and heated, and she punched a hole in the wall, and she was intimidating other jurors, and it was really, really unusual. Despite all of this juror misconduct, that man was still executed in October. So when we think about the integrity of the process, I want to talk a little bit about voir dire, what you're representing, how, in this case, this juror completely lied, and how ultimately her upholding the will of the other jurors essentially caused this person to receive the death penalty. And I'm curious to hear your thoughts and reactions, Portia Chiffon.
Yeah, I actually went down a doom dive with this case, and it was incredibly troubling that, well, first I just want to shout out the three women on the Supreme Court that are fighting for their lives to, maintain the little bit of piece of sliver of rights, constitutional rights, and just rights that we have as a people. And that's Justice Brown, that's Justice Sotomayor, and that's Justice Kagan, right? And so in both of the cases that we're actually going to discuss tonight, the three of them were actually the dissenters, right? And so I think it's important just to note that they are there really, truly just fighting for their lives. So the first thing I thought was interesting is that the defense attorneys allowed this individual to stand because, one, she was very upfront about the fact that she was a victim of a crime. And she was also upfront. And there was one piece that was similar in the case that she was a victim in. And that was sort of the disrobing, right? The facts of the Humphreys case involved disrobing and stuff like that. And so she was upfront about that. So I thought it was interesting. And because I obviously didn't look at actual trial transcripts, I sort of wondered why the defense attorneys in this case allowed her to remain on, right? And then the second thing, it really does, right? Because this decision is published. And in fact, I believe it was Justice Sotomayor that talked about the fact that, how can community members really feel confidence in jury verdicts if we know, right? We're not guessing, we're not assuming, but we know it is a fact, not a feeling, that there was misconduct in this case, right? And we still allow this person to die. We still allow this person to be executed. And I think, that's the piece that makes this process scary. And that's the part that makes participation in the criminal legal system a real hard sell sometimes.
Absolutely. And knowing how this juror essentially puts in jeopardy the integrity of this sentence is what should be concerning for all of us. Before we can even get to whether or not this man committed these crimes and the punishment that some people think he might deserve, we should be interrogating the validity of this process. And when we have instances like this, where there are questions that are very clearly concerning about what this juror has done and the misconduct that she's participated in, we should be able to put a pause on this execution. At the very, very minimum, look at the Supreme Court being able to evaluate and kind of put what they call as a stay on the execution to really see what happened in this case. And when somebody brings a case up to the United States Supreme Court, the United States Supreme Court will what's called grant cert or grant certiorari. They're going to hear the case. But in this case, they actually didn't even decide to hear it. So what Justice Sotomayor, what she's writing is a dissent from the denial of the granting of hearing the case in the first place. So the facts, there's no kind of like factual or oral argument in front of the Supreme Court. It is just a record that she's been able to review from the lower courts to say, hey, there's a glaring misconduct that has occurred in this case, and we as a Supreme Court should be using our authority to protect the integrity of the process in these types of cases.
Absolutely. And our criminal legal system is so focused on finality. They're focused more on finality than they are with fairness. And if we're focused more on finality, on getting shit done, on the outcome as opposed to the process, again, how can people how can people feel confident in the criminal legal system, right? Whether it's the belief that the individual that is the accused, right, is the actual individual that did the crime, the belief that the outcome is the right and just outcome, right? Or the belief that my participation in this bullshit is going to yield justice, is going to be fair, right? Like, shame on it all. And, this case is a terrifying example of all the ways in which we really do put finality before fairness. I remember I was doing a jury trial about a year and a half ago. And the judge is like, "Can we speed this along?" And I'm like, "What? Somebody's liberty is at stake. Where do you have to be? You paid to be here just like me. What is the rush? Why are we so pressed, whether it be to execute someone or to convict someone?" And I really, reading this case, and one of the other ones that we're going to talk about really had me thinking about how we truly put finality before fairness. And as lawyers, right? Often, like, judges are lawyers prior to them being judges, but oftentimes judges rarely have actually done trials, right? And this idea that I want to get this done, I want to hurry this up, as opposed to let me be, right, really involved, let me be focused, let me make sure that things are happening the right way, so that people do have confidence in the criminal legal system.
Absolutely. I want to read for folks just two paragraphs from the Justice Sotomayor's dissent from the Supreme Court not granting.
Absolutely. I was going to ask you to do that.
cert.
You read my mind.
Yeah. Okay, here it is. On the second day of deliberations, quote, even when the other 11 jurors voted for life without parole in an internal poll, Chancey would not even consider it. And Chancey is the juror who misrepresented her bias. At that point, the foreperson wrote a note to the trial court explaining that the jurors were, quote, unable to come to a unanimous decision on either death or life imprisonment without parole as a sentence. Chancey, believing the note as written would result in a mistrial, revised the note to say that the jurors were, quote, currently unable to come to a unanimous decision. The court then instructed the jury to keep deliberating. Chancey then, quote, snapped. She yelled, cursed, and screamed that she would stay there till forever if that is what it took for Humphreys to get death. She then threw the victim's photos across the table and demanded, "Do you want this to happen to someone you know?" She reminded the jurors of the similar details of her own attack, and then told them that they had to reach a unanimous decision or Humphreys would be paroled, which was not true under Georgia law. She then levied personal attacks against the jurors and refused to engage in any debate. Perhaps unsurprisingly, jury deliberations almost completely broke down. Screaming could be overheard from the courtroom, and one juror, quote unquote, took a swing at Chansey and punched a hole in the wall. Jurors were seen crying on several occasions, and a juror later recalled that it was as if an evil force took over Chansey. I could not imagine being in the courtroom, hearing all of that going on, and not being able to have a mistrial declared. Portia Chiffon, when there is a mistrial, does that mean that the person is let free?
Well, it depends. It depends on whether or not that individual was free during the trial, right? Because a mistrial doesn't mean that there's a conviction, and a mistrial doesn't mean that the person was acquitted, right? Found not guilty. I've actually have had several mistrials, and there were mistrials where my client was in during the trial, and they essentially remained in while we waited to see if the trial was going to happen again. And I just want to note for the community members that are on the call, when we're talking about a mistrial, we're essentially saying that the jury could not reach a verdict or something happened. Again, to cause there to be an issue with the integrity of the process. And as a result of this issue, or as a result of there being an inability to reach a verdict, the judge will grant a mistrial. And that simply means that this case could be tried again. You know, that's what a mistrial means. It actually doesn't mean finality. It means that because we didn't get finality this time, the individual can the individual can be tried again.
Thanks for that clarification. And in Humphrey's case, he was in custody, and a mistrial would not have let him go. I know sometimes people
No,
are concerned about the safety of the community,
right,
but I really appreciate you lifting up the point is that nothing changes per se. It just means the case is still open, right? The
right.
prosecution still has to, if they want to, pursue that case and try to obtain a conviction. Before we go to the next case, I want to invite anybody that might be listening in, throw your questions in the comments, and we're happy to answer them. There's another case that I want to talk about. It also relates to the application of the death penalty, and it happened within a month, I believe, of this particular case, if I have my notes correct. And this
Well,
is the case. Yes.
Well, before you get to that other case, I actually want to note a question that we received.
Mhm.
And before we, start unpacking that other case, the question is are there no pathways for other jurors to report aggression and other misconduct of another juror to some representative of the court?
It's a great question. I'm just going to keep reading from this decision because it addresses this
Absolutely.
very issue. Um,
Yes.
so the foreperson even wrote a note asking to be removed from the jury because of the quote hostile nature of one of the jurors. The court instead gave an Allen charge and instructed the jury to deliberate. It also rejected defense counsel's renewed motion for a mistrial. On the third morning of deliberations, the jury returned a unanimous verdict of death. So to answer your question, right, the foreperson who shares this note with the court that they don't feel safe or that they're concerned with how this other juror is being so aggressive, that should have been honored and at least investigated a little bit to see what was going on. Undoubtedly, the court themselves were able to hear all this yelling and arguing that's going on, and the fact that they didn't, look a little bit more into the nature of this, the foreperson's note saying that they didn't want to be on the jury anymore because of the hostile nature of one of the jurors. That should have been looked into. Some of the things that the court might have been considering is if the foreperson is removed, are there alternates still there? Now, sometimes when you have a 12-person jury, well, almost all the time, you'll have two alternates. But sometimes when the jury goes to deliberate, the alternates are sent home. Now, I've seen judges, and I want to give a shout out to Judge Nandi Campbell here in New Orleans. She kept the alternate jurors in the courthouse until the jury had their verdict, just in case, a juror who was part of the deliberation got sick or maybe had a scheduling conflict or anything. She kept those alternate jurors on standby just in case he would have to pop them in. But in this case, I don't know if the alternate jurors were still there, because usually I see judges just kind of dismiss the alternate jurors once the deliberation process begins. But to answer your question, the natural pathway to report that aggression is to send that note to the judge. And it's really concerning that the judge didn't take the appropriate action in response.
Right. So for community members that are on the call, a foreperson is simply the first individual to be selected to be on the jury. And the foreperson is the individual once the jury goes back to discuss the case and decide innocence or guilt. That process of discussion of the case is called deliberations. Now, when the jurors are in the back in private discussing the case, discussing whether or not the person is innocent or guilty, if there are questions, or if the jurors have or if the jurors need clarification, or some judges don't allow jurors to take notes, so if they forgot an element of a crime, they can send a note to the court. They can send a note about misconduct. They can send a note about aggression. They can send a note about anything. And the court will bring the jury in and they will explain whether or not they can answer the question, whether or not the court needs more information before sending the jury back to discuss the case. One other thing that I want to note is that alternates are the extra individuals. They're in excess of the 12. So the 12 jurors that are selected, the first 12 are the main jury. Those are the individuals that are going to the back to discuss the case. Now, the alternates are the individuals, these are pinch hitters, right? These are the individuals where if one of the main jurors gets sick, that jury will step in. If something happens and one of the main jurors simply can no longer serve, then that alternate juror is ready to step in. The alternate jurors sit through the entire trial with the main jurors so that they are prepared to step in if one of the main jurors can no longer serve. Will, is pinch hitter correct? Like, is that the correct sort of analogy for the alternate juror?
Yeah,
Okay.
yeah.
Pause for consistency.
I had a quick follow-up question for you. In New York, is the first juror always the foreperson?
Yes. And I'm so glad you said that because I wanted to be very clear. I don't know if that's in every single state, but I
It's not
can tell you,
Louisiana.
I figured in New York, the foreperson is always the first juror
Interesting.
to be selected. Yes.
In Louisiana, the foreperson gets selected at the end of the case after the jury has been charged. And when they go into the deliberation room, they have to decide who the foreperson is going to be.
That's so interesting. Also,
Yeah.
there's actually one thing that before we move on to our other case that I wanted to note, and I don't know if this is also true in Louisiana, but in New York, once the jury starts to deliberate, and if something happens to one of the main deliberating jurors, it is the accused that makes the decision about whether or not to seat an alternate. So,
Oh,
yes.
interesting.
So I will tell you, for those of you on the call that are attorneys that have ever practiced with me, I do not see alternates. I do not see alternates on principle. But in New York, once the jury starts deliberating, the only way that an alternate can get seated is if the accused agrees.
Mm. Another follow-up question. Do the alternate jurors know they are alternate jurors?
Yes.
So another shout out to Judge Campbell. She didn't tell the jurors who was an alternate. And
Oh,
so
wow.
everybody's listening as that they have to deliberate. And I worry
Mhm.
if I know I'm an alternate, maybe I'm not paying as much attention. So
Right.
that's really interesting. Okay, I want to. We have two more cases to talk about. One is Anthony Boyd, and the other is about the gentleman who was acquitted for throwing the sandwich at the law enforcement officers. So Anthony Boyd, I want to read to you all a quote from Mr. Boyd as his final statement before he was executed. He says, quote, "I did not kill anybody. I did not participate in killing anybody. There can be no justice until we change this system." Mr. Boyd was executed on October 23rd, 2025, and he was killed via a mask, hypoxia. So they put a mask on his head and they filled it with nitrogen, and that was the method of execution. What's unique about Mr. Boyd's case is that it was a jury of 10-2 that voted to recommend the death penalty. We've talked about non-unanimous juries before as it relates to the verdict for guilty or not guilty. Alabama is one of those states that still allows non-unanimous verdicts for the sentencing phase of a death penalty case. And I think Florida might also allow non-unanimous juries for the sentencing phase of a death penalty case. And so when we think about the history of non-unanimous juries, we've talked about it in Louisiana. It was really rooted in a scheme to nullify the votes of Black people that made it onto the jury. And similarly, in Oregon, that also had non-unanimous juries, it was rooted in nullifying the votes of Jewish people from serving on the jury, so that the predominantly white Anglo-Saxon Protestant community in Oregon could proceed with their vision of justice. And then in Louisiana, the white people very much thought, with the 13th Amendment abolishing slavery, with the exception of criminal punishment, how do we continue to perpetuate this convict leasing system to replace this free labor that we lost with enslaved people? So non-unanimous verdicts, non-unanimous juries from a verdict perspective no longer exist in the United States, but non-unanimous votes as it relates to the sentencing phase, determining whether the person is sentenced to life without parole, or said differently, whether they're sentenced to die in prison or they're sentenced to die via execution. So Mr. Boyd's case is on our radar because of the nature in which he was executed, but also because it was a case where there was a non-unanimous decision to sentence him to death.
Absolutely. And just one thing that I want to head note just about Mr. Boyd's trial. Mr. Boyd was on trial with 3 other co-defendants. The only connection to the crime that the prosecution was able to present to the jury that Mr. Boyd participated in this crime was the testimony of his co-defendant. There was no other evidence linking Mr. Boyd to this crime. Nothing. It was just the testimony of his co-defendant. That's piece number 1. But what is really notable about this particular thing is that he wasn't in that moment begging not to be executed. He was asking for mercy for his execution. He wasn't asking for a painless death. He was asking for a less painless death. For those of you who are not aware, dying by nitrogen hypoxia, you could potentially suffocate between 4 and 7 minutes. All Mr. Boyd wanted was to die by firing squad, which would have meant he would have been unconscious within 3 to 6 seconds. All he was asking for was for humanity. That was it. And I think again, right, it really makes you question the integrity of this whole process if we can't even allow people's life to end, right? They're paying the ultimate price, right? For those of you who believe, do the crime, do the time. What this man was simply asking for was to pay his price, was to do his time, the ultimate time, right? Death, just more humanely. And it was really gut-wrenching sort of reading, just his last request. And not just what his last request was, but really just the agony that he unnecessarily suffered as a result. To be clear, his request was denied and he was sentenced to death by nitrogen and not firing squad.
Yeah, and his execution is the longest one on record in the United States.
Mm-hmm.
He suffocated for 38 minutes before he was pronounced dead.
Oh my God.
And we think about this idea of not being subjected to cruel and unusual punishment, right? If the sentence is for the person to be killed, why would we want to torture the person as part of that sentence? And I appreciate you listening at the point that he wasn't asking for to be released. He wasn't asking for his sentence to be converted to a life sentence in prison. He was asking for, as you said, and as Brian Stevenson reminds us, just mercy, right? Thinking about a more kind of I don't want to say humane way to die, but a different way that wasn't going to prolong his torture as part of that execution. So this was another case that Justice Sonia Sotomayor chimes in on. She says, imagine during that entire time you are suffocating. You are strapped to a gurney with a mask on your face that forces nitrogen gas into your lungs. Your mind knows the gas will kill you, but your body keeps telling you to breathe, right? And there are people who I know that support the death penalty and will say, well, he didn't have any mercy when he committed these crimes or tortured this person or whatever he was accused of. Are we going to use a person's conduct in a crime that they have committed as justification for the government to also, commit this type of violence against somebody? What the death penalty is, it's state sanctioned murder. That's what it is. It's state sanctioned murder. And if we aren't going to explore ways to, as humanely as possible, discontinue somebody's life, if that is the very sentence that has been carried out, then are we any better than people who are committing violence in other forms, right? I think there's a lot of things we can be interrogating with the ways in which Mr. Boyd was being executed. And the fact that unanimity is not required is something that should be concerning for all of us.
Absolutely. No pun intended, but it really made me think, both of these cases made me think about Portia and Shakespeare's Merchant of Venice, right? And it really made me think about her begging or her really interrogating why we as a society, why we as a criminal legal system always have to have a pound of flesh. Just because we are around animals doesn't mean we need to become one, right? And, we really need to unpack so many of the lies our teachers told us and so many of the sort of inhumane and barbaric ways that we've been socialized. We really, as a community, conflate accountability with punishment. And I think, again, when we are talking about the integrity of this process, that also means that us as individuals that are participating in this process really need to think about where on the spectrum of humanity we fall, right? And Mr. Boyd's case really had me pondering that question. But
Yeah.
they end on a good note. We're going to be talking about Sandwich Guy. But
Hold on one
before we
second.
do that, what's up? Oh, yep, that's what I was about to say.
You know how the DJs have that little. I was looking for that button when you said just because we're around animals doesn't mean we need to become them. I thought that's just really, really powerful. And I'm gonna figure out how we get these sound effects that I can
Oh,
add
don't
in.
let me get my hands on sound effects.
Or I'm gonna have a DJ Khaled, another one, another one. Sorry.
Wait, we actually, speaking of another one, we got another question.
Yeah. So the question is, if we advocate for more humane methods to carry out a death sentence, does that undermine advocacy to make the death sentence illegal? Period. Love this question. I
Mhm.
think we can do two things simultaneously. I think we can, one, acknowledge the system that we have and try to improve the current administration of this criminal legal system, while also advocating for the abolition of the death penalty. The work of the Equal Justice Initiative really does a great job highlighting the inaccuracies that are carried out through executions. About 15 years ago, the statistic was 1 in 10 people on death row are innocent. I think the most recent reports about 1 in 8 people on death row are innocent. And the analogy that Brian Stevenson shares, he says, if we knew that 1 in 10 or now 1 in 8 airplanes would crash, would we ever fly on one of them? And the answer is no. So I think we can critique and criticize the current administration of the death penalty while simultaneously saying, hey, we shouldn't be having this in the first place. What are your thoughts, Portia Chacon?
Pew, 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 pew. That's my thought. Absolutely. Will, in our last, I could not agree with you more. Actually, that requires no follow-up whatsoever. I resoundingly agree with you. In our last few minutes, I want to get to you were about to say something and I cut you off with my shit talking. What were you about to say, Will?
No, thank you for that question. And if folks have more, go ahead, throw them in the chat or in the comment box. What happened with this case in Washington, D.C., where this guy threw a sandwich at some officers? He wasn't indicted, but he was taken to trial. Kind of give us the top lines of what happened with that case.
Yeah, I'll try to streamline this in a time that we have left. So basically, this white man goes up to several officers that have occupied DC, and he's yelling at them, screaming at them, calling them fascists, all the things that they are. And then right before he runs away, he throws a sandwich at them. He gets about a block away before he's arrested. They tried several days and several ways to get an indictment on this man, and the community spoke. The U.S. Attorney's Office could not get an indictment, so they did a workaround and they tried him without getting an indictment. And the community spoke again, and they acquitted him.
Was he charged? Was he taken to trial via charged with a felony or a misdemeanor?
A misdemeanor.
A misdemeanor. Okay. So we have the community speaking in two different instances, right? So we need to remember, cases in America can be filed in one of two ways. One is what's commonly called a bill of information, and there are certain types of charges that only require a bill of information. And then there are certain instances where you have to get a bill of indictment, and that's going to be secured by a grand jury. We have to remind ourselves that the framers of our Constitution knew the value of the jury kind of being the last line of defense against the tyrannical government, right? So the grand jury decides whether or not to charge somebody with a particular crime. And the threshold to do that is probable cause. You fast forward to the end of a case, if somebody goes to trial, you won't have a grand jury. It's called a petit or a petite jury that is deciding innocence or guilt. So the grand jury decides whether or not to charge somebody with a crime. They start a case, and then the petit or petite jury, they decide innocence or guilt, and they essentially end the case. And in this example, what the community was saying at the beginning is the same thing that the community was saying at the end, that we don't believe this man, A, should be charged with this crime, and then B, should even be convicted of it.
Absolutely. He was ultimately brought to trial for misdemeanor assault, and he was acquitted of misdemeanor assault. And at this point now, he is the symbol of resistance. But I want to highlight, before we get off of this live, I want to acknowledge all of the grassroots organizations in Chicago, in DC, in New York, in Louisiana, in the South, in the West, in the Midwest, all of the dope stuff that y'all are doing. We see you, we support you, and please reach out to the Juror Project to figure out if there's a way that we can also support you. But while we are incredibly happy for Mr. Dunn, aka the Sandwich Man, we want to acknowledge all the Black and Brown and Indigenous organizations that are boots on the ground across this country that are doing that work as well, in all of the ways, for all of the days. So we want to say thank you for that as well.
Thank you for those closing words, Portia Chiffon, and thank you everybody for joining for this evening's Jury Duty Unmasked. We look forward to seeing you in December, and we hope you all stay safe until then. Good night.
Pew, 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 pew. I love that. Good night, everybody. I'm just playing. Good night.
Bye.